possibilities that exceptional circumstances exist in the interest of judges that permits his release. That is the issue before this honorable court. And for this court to come to a conclusion whether to grant or refuse, that will be entirely based on the evidence that has been placed before this honorable court by applicant number one, and of course the investigation officer who also testified, Captain, in this matter. It's also so that applicant number one is facing the charges of murder, right with the provision of section 51 subsection 1 of the Act of 105 of 1977, and secondly that robbery with aggravating circumstances. Those are the charges that applicant number one is facing. And there's allegation that there was common purpose, of course, we charge it between applicant number one and number two. Now, even before I proceed, I think whatever that I'll be addressing the court going forward, respectfully submit that the court should take also that into account. The admissions that were made by the state in terms of 222 of the Criminal Procedure Act. Formal admission, one, that the people swab that were taken and the fingerprints that were uplifted on the car of the deceased, that the reports, therefore, exclude one of the applicant, which we don't know whether it's one or two, but to suffice to say the other one result is inconclusive, and therefore the other part of it is that the blood that was in the car of the deceased belonged to the deceased. That piece of evidence is very crucial. It's one of the aspects that would inform the court in terms of making its finding as to whether applicant number one should be granted bail or not.
Yes, sorry to interrupt you, sir, but I did not hear any evidence or admissions made with regard to the outcome of the fingerprint analysis, only in respect of the DNA analysis.
Bishop, only the DNA analysis in respect of the Baki.
The Baki, okay.
Yeah, only that, and that is with specific reference to the analysis that was done by the private laboratory, not that of the
Okay. Because I hear Mr. Kolanyana speak about the fingerprint results.
Worship, let me put it this way. In terms of the evidence of the state by the captain, those results have not been made available yet. But my submission is that at this point in time, at this conjuncture, we don't have fingerprints evidence that linked applicant number one. And for me, that is crucial. And if I have to proceed, then, Your Worship, my submission is that the principle, the law and the principle that is applicable in this matter, Worship, is that we agree, of course, with the state. And as I said, it's common cause that the bail application of applicant number one is governed by the provision of section 60, subsection 1A of the Criminal Procedure Act, which provides that, and I quote, notwithstanding any provision of this act, when an accused is charged with an offense referred to in Schedule 6, which is the situation in this matter, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist, which in the interest of justice permits his or her release. Close quote. The above provisions should be read in conjunction with section 12, subsection 1A of the Constitution, which provides that everyone has the right not to be deprived of freedom arbitrarily or without just cause. I take this furthermore, section 35, subsection 1F of the Constitution stipulates that everyone who is arrested for allegedly committed an offense has the right to be released from detention if the interest of justice permits, subject to reasonable bail conditions. Now, for this honorable court to come to the conclusion as to whether applicant number 1 has disclosed and discharged the honors, one has to look at the evidence tendered before you. Yes, we concur, I concur on behalf of applicant number 1 that the honors is on him. Applicant number 1 testified. He had an option of supplying an affidavit, but his instruction that I want to expose myself to cross-examination by the state, and he elected to testify. I'm going to repeat and waste the court's time with this testimony. And I've realized from the beginning of the time the court was taking notes, unless there's any aspect that the court would want to engage me. But in a summary, he was a good witness. He never contradicted himself. He stood by his version, even under lengthy cross-examination from my learned colleague from state, Mr. Harrington. He stood by his version. The unfortunate, or want to say fortunate, part of the bail proceedings is that the defense does not have access to the docket. Now, whatever the applicant said, it was account of what he knows and what happened. But from the onset, it's his testimony. He testified with the cooperator of the police. He indicated to the police, I don't know anything about the murder. When he is asked, in fact, where were you? He said, I was at home the whole night with my girlfriend. Yes, I was at the tavern on the 3rd drinking, but I was not with applicant number 2. I know him. Polori is not a big place. Most people don't know each other. He said yes to the court. He's not saying far from me, where I'm staying, but we are not friends. There's no absolutely no relationship. And when we were arrested, I was not sitting with applicant number 2. Your Worship, he's arrested. He said to the police, I don't know anything about this. He went with the police at his house. Police searched. They found a pair of trousers with blood stains. There he's asked to explain. He said, these brothers came, the blood stains was due to the function that I attended at Pinky's place. I was slaughtering there. And obviously, we were speaking with the phone, my pockets, and that's how the blood stains landed on the trousers. This man does not even know what is contained in the docket. He doesn't know who are the witnesses against him. For the police to go to Pinky, they would have not gone there unless with the information that got from applicant number 1. The shack is searched, which belongs to one, we call it a shack number 1. There's another shack, he said, that was my brother's shack. The police went there, they said, accused said they saw a plastic, he didn't know what was it, he only asked the court and questioned him, he said, I saw a jacket in the plastic while we were at the police station. And the police said, no, but this cloth, piece of straw was found in the defreeze in his shack, and he disputed it. He said, that's not correct. I never said to the police, this is my para shack, it's locked, and he went to fix back. That's the testimony of applicant number 1. He does not have any previous criminal record. He's got a pending case. He was released on bail of 1,000 rand. He attended the bail proceeding throughout. At no stage he defaulted once. He said, I never lied to the court regarding the issue of Pinky, my brother. Never lied. Now let's deal, because I think that is more, one would say, evidence that incriminate applicant number 1, the girlfriend. But what is crucial that the girlfriend said, yes, he was there. We slept together. I woke up at 11, he was not there. He came back at 4. The state witness, the captain, said no. The witness that said no, they saw him around about 4, 6 o'clock in the morning coming from the direction of the mountain. Just immediately after the incident. Surely that's a crucial piece of evidence. And there's glaring material contradictions in it. the issue of Pinky. Pinky does not say there was no function. I would submit respectfully to this court. If the investigation officer said, the captain said, Pinky has made a statement under oath and she says there was no such a function, it could have changed the aspect of Pinky and the evidence of him attending it in a completely different light. But Pinky conceded there was a function at my place. But what she disputed, with the greatest respect, Your Worship, whether she saw applicant number 1, 2, whether he was slaughtering. And when I gave a background to the investigation, I did that deliberately so because it's crucial. In the black community, when we have this kind of function, not only the feast, even in funerals, you don't get an invitation to attend a funeral. It's culture. Everybody, neighbors, Ubuntu, you just join the funeral. You go and assist where a feast. You don't need to be granted permission to come and assist and slaughter. And normally people who do slaughtering are men. Now, I submit to you that it's possible that Pinky is making a mistake, not intentionally, bona fide mistake. She didn't see applicant number 1 at the scene and the slaughtering. The evidence that there were 4 people, 50 people there, it's uncontested by the state. This is the evidence of applicant number 1. Now, that also shows that the high probability that if there was that large of people, the chances are very high that Pinky was not there to notice who was there, who was not there. She was responding to what she was asked by the police. I didn't see him. I didn't see him slaughtering. I know him. It cannot be concluded that applicant number 1 is lying about that. It can't be. It's highly improbable, if it's in his favor, that, as he said, he was there. At that time when he provided that information, he didn't know what is in the docket. There's an honest man who cooperated with and say, this is what happened. Ultimately, the state feels that he lied. And I will submit to you that in all those situations, I can't see anything that applicant number 1 was lying to the police. Instead, it's the opposite. He cooperated with the police. Physical evidence that links applicant number 1, no. DNA, no. Eyewitnesses, no. What should that tell the court? Take into account the admissions 220 that were made by the state. The state case is based on circumstantial evidence, not just circumstantial, but weak circumstantial evidence, if non-existent.
Mr. Khulanya, sorry to interrupt, but is your client following your submissions in English? Or?
Worship, can I thank you, Worship, for that? Can I quickly just find out that they would need it up there?
Okay.
Thank you, Worship. Thank you, Worship. Apparently, he thinks he requests that he be interpreted, though it means we have to proceed, because he thinks he wants to hear my argument. Thank you, Worship, for raising
Mr.
this.
Simanga, will you assist?
So I'll try to be short and give the opportunity. Your Worship, if you take that and see what is left, evidence from the state that linked applicant number 1, it's statements of witnesses that were drinking at a tavern, who made allegations of applicant 1 was incriminating himself, boasting of what has happened. They assaulted a white man at a farm. I've already addressed the girlfriend's statement. I'm going to repeat myself. The statement of the brother. There could be reasons why he said today, if it's not, I'm not staying there. There's so-called trousers, clothes found in a freezer, in the so-called kitchen. And knowing that it's hot, he decided to say, police, no, I don't know, I'm not using that. That could be the reason. I can't think of any reason why you refused to accede that. In fact, that place is used as a kitchen and he also uses it. He said, no, I don't know anything about it. That's all the state has against applicant number 1. person comes of the applicant is on the record, I'm not going to repeat it. And Captain Mabel already testified. I don't want to be low, but I could just say and make submission that his testimony was rattled with contradictions and highly improbable events, chain of events. Important aspect of evidence that the state advocate is supposed to have put to the witness, especially when I'm referring to applicant number 1. And I asked him why that was never put, and my submission that if Ms. Harrington was told that information, Your Worship, he would have put it to the state, to applicant number 1. He said, no, the information is in a docket. I don't know why he didn't do that. He was all over the show. When he's confronted with evidence, if not 70 to 80%, he said, I don't have a comment. I don't know. But I know the onus is not on the state, it's on the applicant. But the evidence of investigation, especially when the state opposed bail, is crucial to assist the court to arrive to an informed position as to whether to grant or to refuse bail. There is only one reasonable inference that I can draw from the captain. He didn't know what is happening in this matter at all. So he didn't assess the case, this honorable court at any stage in terms of the reasons why he's opposing bail. He just said the state case, it's strong against applicant number 1. When I put it to him, it's very weak. He said, no, I don't agree. That's what his comment. The main contention, and this was taken by Malene Mr. Mutlung, at some stage the court also asking, was that the issue of civil unrest. That was crucial in his testimony. That if applicant is released, initially there will be unrest. But we know later he conceded to Mr. Mutlung to say, it's far-fetched. I'm not sure. It might not happen. I don't know. Your Worship, I refer this to the court to S versus Rudolph. 2010, Volume 1, SACR 262, Supreme Court of Appeal decision. And the following was stated by the court regarding exceptional circumstances. And I quote, exceptional circumstances do not mean that there must be circumstances above page 262. Your worship.
Paragraph.
Paragraph 266 to G to H, sorry. Paragraph G to H, page 266. This is what the court said. Exceptional circumstances do not mean that there must be circumstances above and beyond. And generally different from those enumerated in section 60, subsection 4 to 9. In fact, ordinary circumstances present to an exceptional degree may lead to a finding that the release of bail is justified. The Act does not spell out or provide a list of exceptional circumstances. In S versus Isaac, 1965, Volume 2 SA 161, Paragraph D, the court held that the presumption of innocence operates in favor of the applicant, even where there is a strong prima facie case against an applicant. And in a submission in this case that the case is weak or it's non-existent. In S versus C, 1997, Volume 2, SACR, CBD, the court ruled that Section 60, subsection 11A of the CPA should not be interpreted to mean that the procedure is punitive. Bail is not punitive, it's to make sure that the accused will come to court. The section merely means that the court should exercise exceptional care in assessing usual circumstances. My submission before the court is that the provision of subsection 64A to E don't find applicability in the case of applicant number 1. There's no evidence before this honorable court. In fact, the evidence that's placed before you favors the applicant number 1. There's no evidence that he will interfere with the state witnesses. Doesn't know the witnesses. The only 2 witnesses that he knows is the brother, the girlfriend, and Pink. But he has no reason to intimidate them. not to testify against him. There's no likelihood that it will endanger the safety of the public. There's also no evidence that will evade trial. In fact, there's evidence on record that favors applicant number one. Yoship, he was on bail throughout. There's no evidence. The investigator was asked, he never defaulted. He was always at court, all the time. The individual fellow said no, because he knows that if he's found guilty, he'll go to an imposed sentence of high will be imposed to him. But my submission to the Supreme Court that is that why would he, as much as he's aware of that, but why would an innocent person who didn't commit an offense run away, irrespective of the sentence that is imposed upon him? The court could not be expected to say there will be unrest just because of the event of the 6th of October. Acts of criminality of white who stormed in here and wanted to take both applicant 1 and 2. It cannot be based on that, that because of that, if this applicant number 1 is released, there will be unrest. In Matebula versus the state 431-2009 Supreme Court of Appeal, the court confirmed that the principle as indicated in S versus Border and S versus June, that an accused must prove on balance of probability that he will be acquitted of the charges. That on its own, the court said, it's an exceptional circumstances. And with the greatest respect for you, Oship, I submit now that if tomorrow, next week, this case can go on trial, with the evidence that we have now before you, applicant number 1 will be acquitted. This is a clear 174. And lastly, before I sit down, Yoship, I'll refer this court to S versus D and others. And Judge Lukhodi J said that the low risk pertaining to flight, the absence of likelihood of interference with state witnesses, and the low risk of reoffending constitute an exceptional circumstances. If the court looks at the weakness of the state case, the provisions of subsection 60, subsection 4A to E, I submit before you that applicant number 1 has successfully discharged the honors placed on me by the law. submit that it is in the interest of justice that applicant number 1 be released on bail. And of course, the court will remember, he said even the condition could be imposed. No interference of the state witnesses. If he has to leave Poloru anywhere with work, that the investigative officer be informed. There are conditions to make sure that the applicant would not interfere, or the fears of the state in this matter. He's a South African national. He's got an ID. He does not have a passport. Where would he go if he evades justice? That's a call. Thank you, Oshi.
Mr. Madonna.
As the court pleases, Your Worship, I'll attempt to just provide this honorable court with a high-level summation of the issues pertaining to this bail application, and I would therefore request this court, in the event that there are certain aspects of my address which perhaps needs clarity, the defense would be available to provide such clarity. Your Worship, we're sitting here with an application for the release on bail on behalf of applicant number 2. There are constitutional issues and matters of public interest and importance in this bail application. I'll pause for a moment and deal with the interpretation of section 60, subsection 4, A to E, which, in my view, is the cornerstone of application of this nature. As a point of departure, Your Worship, the factors listed in section 60, subsection 4 are not determinative of interest of justice, but they are relevant pointers. In construing section 64 to E, a two-stage approach is warranted. I will thus draw a dichotomy between these two stages, the first being a factual inquiry into whether the factors listed in subsection 4, A to E are present, I would overlap on this point to say, if there is absence of factors as listed in section 60, subsection 4, A to E, then the accused must be released on bail. I humbly submit to this honorable court that with regards to the first stage, which is a factual inquiry, which in essence does not involve exercise of discretion, that the court must assess facts. The purpose thereof, Your Worship, is to assess the likelihood of risk to the, for the purposes of bail. Of interest is a decision of in State versus Dlamini. It's a constitutional court decision where the court looked at the notion of likelihood. Your Worship, I will marry the explanation on likelihood with the evidence that is presented, that has been presented to this honorable court. Likelihood means that there must be a probability that such risk will materialize. A possibility or suspicion will not suffice. Let me pause and deal with the evidence that was tendered before this honorable court. The applicant number one, number two, bearing the honors to prove on the balance of probabilities that exceptional circumstances exist that permit his release on bail. He discharged of that honors by deposing an affidavit which detailed his personal circumstances, inclusive of his sentiments with regards to the charges that he's currently facing. The existence of exceptional circumstances in applicant number two's case primarily hinge on the weakness or otherwise of the state's case against him. To this end, Your Worship, all that applicant number two is presenting to this honorable court is that he was at no stage at the scene of crime, thus he vehemently denies any involvement whatsoever in the commission of the crime. Mindful of the fact that in a bail application, there are limitations in as far as adducing of evidence. Furthermore, that there is the court has no obligation at this stage to make a determination of the guilt or otherwise of the applicant. But applicant number 2 chose, not now, but upon his arrest, to reveal the basis of his defense. The defense will look microscopically into the evidence as tendered by the captain or the witness for the state in opposition of applicant's release on bail. As a departure point, I submit with respect that the evidence of Captain Mabel is wobbling as and was found to be in despair. One had an impression that, and this impression is well vested on the evidence that was presented by Captain Mabel, that majority of what he was testifying on was but what he doesn't know. If one sifts through the evidence, as a starting point, Your Worship, the information that Mr. Mayberg is relying upon is also riddled with discrepancies. Otherwise, how does one explain that the 3 male persons were seen coming from the direction of the crime scene by an independent witness around 6 o'clock in the morning, whereas the girlfriend to applicant number 1 gave information to him that applicant number 1 arrived at home at 4 o'clock in the morning? Surely something is visibly so wrong in that piece of evidence. How does one explain, Your Worship, some evidence, some piece of evidence that is introduced into this court through a back door, such as information that witnesses might have told him, or rather witnesses told him, of the alleged conversation between the accused in a tavern, when that information was never adduced to this honorable court on Friday when he was giving evidence in chief. Your Worship, I submit with respect that there are myriad of issues that would point towards the hopeless nature of evidence tendered by Captain Mayberg. And one cannot also ignore the apparent desperation that is clear in his testimony with regards to trying to link accused or applicants to the offense. In actual fact, Your Worship, what are the reasons for the opposition of this bail application? His chief reason, Captain Mayberg, is that the release of applicants on bail might lead to public disorder and unrest. Albeit my learned colleague has already alluded to the very important concession, which was actually extracted from the witness with regards to non-existence of that fact of unrest. Much as he has made that concession, difficult that it was for him to make that concession, that there is no likelihood of unrest. I submit with respect that if there were to be any unrest as a result of the release on bail of the applicants, same would have been experienced even in the related cases where bail was fixed. Now, Your Worship, this aspect is settled. What are we remaining with? The residue that is left of his evidence opposing applicant's release on bail is now on interference with state witnesses. I revert and reiterate this point made earlier, that a court must assess the facts. The only fact which also was introduced through the back door is that at some point, somewhere in Putadichaba, there was a call to one of the witnesses, threatening the witness in respect or relating to this case. Is this a fact that was concocted? One is inclined to believe that this was just but one of his antics to try and show, desperately so, that applicants, particularly applicant number 2, will interfere with state witnesses. Otherwise, Your Worship, how does one explain the further explanation that deviates from the impression created during his evidence, when he responded to the question, to say that in actual fact, the said brother-in-law did not directly attempt to intimidate the witness, but rather it was done through a third party. I humbly submit, Your Worship, that it is so incomprehensible for an experienced investigating officer with 23 years to provide evidence of such poor quality. As indicated, Your Worship, there are assortment of factors that support this conclusion that I've made, or submissions. Your Worship, I would step from the evidence by the state and continue with the proper application of section 60 subsection 4 of the Criminal Code. That the correct interpretation of this section should be read with section 35 1F of the Constitution. Your Worship, I submit that if one gets to the second stage, I've alluded to two-stage approach. The first stage being factual inquiry. The second stage, Your Worship, would be application of the law. And in this instance, the correct approach is to determine the probabilities in order to assess the future conduct of an accused. Your Worship, there is evidence of previous convictions in respect of applicant number 2. Surely, that is relevant for purposes of bail application. Submit, Your Worship, that past conduct is definitely not immaterial. But definitely it is not decisive. Particularly if we look at the lapse of time wherein the applicant number 2 was last in conflict with the law. The latest previous conviction is almost 9 to 10 years back. Your Worship, Section 35, 1F, makes it clear that the interests of justice are paramount. If we look at the circumstances of applicant number 2, and with regards to what constitute exceptional circumstances, he has raised an alibi that on the day in question, he was at home with his wife. His alibi is confirmed by his wife under oath, and an aspect which was actually revealed under cross-examination. It's a favorable aspect. Conveniently so, it was not revealed in evidence in chief under cross-examination by applicant number 1, but during applicant number 2's cross-examination, this aspect mysteriously surfaces. Your Worship, there is a very salient point that one raised with the investigating officer, which should not be ignored, which is in the absence of forensic evidence, what do we have? Will the state be content and satisfied if applicants are excluded on forensic evidence? Will they be content and proceed with the charges against the accused or the applicants? Your Worship, I submit with respect that during that elimination process, already my learned colleague has made admissions in terms of Section 220 of the Criminal Code in respect of the analysis that was found on the sample, or rather analysis performed on the sample extracted from the, or uplifted from the vehicle that was stolen. Your Worship, I submit that in the light of this latest discovery, that whatever version that the applicants have consistently been putting forward is a version that cannot be, at this moment, shaken by the state. It is on this basis, Your Worship, that I make this humble submission. Strongly so. That the state's case, weak as it is, constitute exceptional circumstances. I will refer this Honorable Court to State versus Nyembe. It's a 2020 decision. It's an Eastern Cape Local Division matter.
2020.
2020. It was heard on the 28th of October 2019, heard by Tony AJ. Particularly, Your Worship, of interest in this matter is the scope of exceptional circumstances. I'll quote, Your Worship, that the court held that cumulatively, the fact that the state case is subject to some doubt, the low risk pertaining to flight, the absence of likelihood of interference with state witnesses, and the low risk of reoffending constituted exceptional circumstances. Your Worship, in this case, the res ipsa locuta principle must be invoked. The facts of this case speaks for themselves. They fit so well with the decision that or rather the passage that I've read. Your Worship, I submit with respect that if we are to rely on the applicant's previous conduct, particularly his previous convictions, that will be an undue reliance on alleged past conduct of the applicant. And this will be inconsistent with the accused right in terms of Section 35(1)(f) of the Constitution. This, coupled with any perhaps decision to refuse applicant number 2 bail will be tantamount to anticipatory punishment. And it is settled law, Your Worship, that bail is non-penal in nature. There is thus a duty placed on courts to be mindful of the fact that bail, or rather the retention and continuous detention of an accused person, which is actually in terms of section 12 of the Constitution, that if one was to keep in mind of the provisions of section 12 of the Constitution, then there should be strict compliance with applicable and relevant legislation that entitles the accused right to a fair trial. Your Worship, I submit.
Mr. Patung, just a moment. Please prepare the details for Thursday. The 22nd. You may continue, Mr.
As a court pleases, Your Worship. Your Worship, right to a fair trial encompass inter alia the right to have your matter brought before a court of law, expeditiously so, dealt with and disposed with in that similar fashion. The investigating officer testified with regards to outstanding investigations. And the length of time in concluding these investigations was put on record. And he is estimating about around 3 months. Strangely, in his world, 3 months is not a long time. But, Your Worship, we're talking here of the right to liberty. We're talking here of applicants who are sitting, languishing in prison for a crime that, for now, we don't have evidence that they've committed. At the very least, as my learned colleague has alluded, the state's case is purely circumstantial. If we were to strictly apply the principle as laid in R versus Blom, with regards to circumstantial evidence, the state's case is limping. Your Worship, it is thus my humble submission before this honorable court that if one looks at the dictates of section 60 subsection 11A, read with section 60 subsection 4A to E of the Criminal Procedure Act, one is inclined to strongly aver that there exists no likelihood as stipulated in the Act of any of those provisions A to E, and thus there exist exceptional circumstances that will warrant the release of applicant number 2 from bail. I'm mindful, Your Worship, of the two-stage approach applicable in bail applications. That once submissions have been made on the appropriateness or otherwise of applicant to be admitted to bail, that the second leg thereto should be to address the issue of appropriate or affordability of bail amount. I will avoid to be tautologous, Your Worship, and just highlight few pointers with regards to the accused or applicant number 2's financial position. Your Worship, as stated on record, that the applicant number 2 is doing odd jobs and is receiving disability pension in the amount of 2,100. He furthermore received child grant in the amount of 1,200 rands per month. His wife is also doing odd jobs in an attempt to augment their financial situation at home. I hereby make a humble submission to this honorable court that in consideration of the applicant number 2's financial position, that an amount of 1,000 will be an appropriate amount if one was to look at the circumstances of the applicant in this matter. In closing, Your Worship, I submit that a proper case has been made out for applicant number 2's release on bail, and I therefore apply for applicant number 2 to be released on a bail of 1,000 rands. Your Worship, this concludes my address to this Honorable Court. I'm available to respond to any questions that the court may pose to me in respect of my
thank you.
address as a court basis.
Sherrington.
Thank you, Worship. My understanding of the argument of my learned colleagues is that the exceptional circumstance that they are taking aim at is the relative strength of the state case in this matter, and it is their version that we have a very weak case at this stage. I, from the outset, would like to disagree with my colleagues, and I do this with respect. Worship, at risk of labouring the record, I would like to deal with the facts of the matter. It is important to note that the deceased was discovered early on the morning of 2 October 2020. The attack on him, the assault on him, must have taken place on the night of 1 October going into the morning of 2 October. And, Your Worship, the investigating officer placed on record as to how the body of the deceased was found, as well as the injuries that he sustained, and he specifically then testified, with his reference to the tying of the body of the deceased to the pole, and then the knife that was left on a hat near the gate, near the scene where the deceased was found. And I submit these issues are important. Early on the morning of 2 October, more or less 6 o'clock, a person, objective and independent, sees applicant number 1 and 2 coming over the mountain in the direction from where the attack occurred. This witness notices that the clothing of both of the men and the third person was wet, or were wet, and then the clothing of the first applicant had bloodstains on them. Worship, what is important here is this witness's evidence is standalone. And what is important is he says to the court, I saw the first applicant, the second applicant, and a third person walking together over the mountain.
Jwale bopaki bona ba paki ena e bohlokwa hobane ke paki e ikemetseng yena o hlalosa hore o bone mmuso wa pele le motho wa boraro.
One must remember that, or it is important in light of the version of the first applicant, that himself and the second applicant do not know each other. They do not spend time together. They are not friends. They are unrelated. This person says differently.
Ma o shebe hape ne ntse bohlokwa hore ke yona motho yona ne mo be o hlalosa ka mokgwa e leng re bona ba hlalosa hore ha se batho e leng ba tsemana ha se batho e leng ba ke ba checkana mo ba se ba go clean mo ha se ba photsi ya bana ka mano ho mara motho yona o bua se fapaneng.
The girlfriend of the first applicant has given a statement under oath telling us the following.
Jwale kgale ena mo ya ba pele mo o fana ka statement le se le pronunciation se le.
They went to sleep together. At 2300 hours, she wakes up. The first applicant is not there in the house. He's not there. She wakes up alone.
Jwale mo re yena o hlalosa hore ba ye ba ya ateng le uswa pele wa pele mo ya re ka mo 11 mo ya mana ale mo yena asa le yo.
She says he returns at about 4 o'clock in the morning.
Mo yena o kutla ka mane ka bona botsana tsa mo 4.
We don't know at this stage as to why she said 4 o'clock and as to why the other witness said 6 o'clock. We don't know how time was ascertained.
Jwale hona tjena ha re tsebe ho ba neng yena a bule taba ya 4 e le ba ke nngwe e bua taba ya 6 eno ha re tsebe hantle ho tlile jwang ho nako e kgone ho ka tseba.
Your Worship, what is of importance here is, we know now that from at least 11 o'clock until 4 o'clock, the second applicant is not at home. Apologies, the first applicant is not at home.
Jwale ho fihla kana ra tseba he mo ka netefatsa mo he o ka le bene ya se fihla ka 4 ya so mo go be ona se la pele.
The version of the first applicant is, I was there, I never left.
Jwale bopaki ba hae ka bona hae o ne ke teng na mo ya kwa tsana.
That is the first question mark over his credibility that I have. But of importance is his absence, according to the girlfriend, who has no motivation to lie about this aspect.
Jwale ke nngwe ya ntlha e re ke e tshwayang ka ke bona hae o ke ho sepa se pei e mo ka hobane ka shebo le le re ya hae e fana ka bopaki le re go fapane ke mo se le se go ya se go tsa mona se pile se go ona so sa mo.
This brings us to the evening of 2 October 2020 at the Bufaku Tavern.
Jwale sena se re tlisa he mane msiuba le ba dithuta tsoba Bufaku.
Here we have two people, independent from each other, objective insofar as their relation with each other. They're not related.
Jwale ke mona ana batho ba babedi ba ile le bona ba nka kamano ho hang he mona.
The first one tells the court, or tells the state, the first applicant, the second applicant, and others were seated together.
Bagina e hlalosa he mona hore go pele ba bobedi le ba 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 na ba ntse mo.
The second witness tells the state, I saw the first applicant and the second applicant seated together.
But can we have if I know sorry, give only what is more?
It is clear from the evidence of the investigating officer that what the first witness overheard was at a different time than what the second witness heard. What is of importance of the evidence is unrelated witnesses place the two men together, and unrelated witnesses says the following: enough information was divulged by the two applicants incriminating themselves on an assault onto a white man on a farm with enough detail that Captain Mayberg informed the court it could not be an assault on anybody else except the deceased. The evidence does not end there. The police then arrest the two accused, and at the house, or at least the yard where the first applicant stays, various pieces of clothing is discovered that is bloodstained. Your Worship, insofar as the, or let me say it like this, when the state cross-examined the first applicant, his first admittance to the clothing was, and the question was, the clothes that were confiscated by the police, to whom did they belong? He said to himself. That was his initial answer. It was only later in cross-examination that the first applicant started to push away from certain clothing. He adapted his evidence with regard to ownership of the clothes that was discovered during cross-examination. And my argument is that he was untruthful in that regard. Your Worship, there is evidence under oath now that the first applicant supplied false information to the police in respect of ownership of the second dwelling, the second shack on the yard. The evidence is that the first applicant told the police the shack is locked, and it was done by his brother, and he left for Vicksburg. Upon investigation, it was found that the shack was open.
ma itse ha tswela pele ka haufinyana hore
A statement of the brother says, of what the first applicant says, it is a lie that it is my shack. The first applicant is making use of the shack, not me. There is no explanation on record as to why the girlfriend of the first applicant would lie on his presence, about his presence on this faithful night. And there is no evidence as to the motivation as why his blood brother would lie and falsely incriminate. That brings me, Your Worship, to a question. Or the following. The brother of the first applicant was not incriminated in this matter at all. He was incriminated, and bloodstained clothes was found in the shack that he lies about. There is a motive. It does not end there. Even Pinky, the first applicant, wants the court to believe he's either lying or making an honest mistake. Collectively speaking, should we now accept that the girlfriend is making a mistake, the brother is making a mistake or lying, Pinky is making a mistake or lying, and that the police are lying when they say the applicant told us the shack is locked? Can we honestly say in light, or can we say that the first applicant discharged his onus? And proved on a balance of probabilities that the state case is failing when we look at the issues with regard to his own version. We know now, and it is of common cause, that the DNA results of the clothing that was confiscated will not be available within the next 30 days. But it is an aspect that cannot be ignored. Bishop, I would like to move over to the law that is applicable. My submission is, I'm not sure if I correctly understood Mr. Mutahung's argument correctly, but my submission to the court is that the departing point in this application is section 60:11 subsection A. That is where we start. Worship, with respect, I submit that there are two cases that is of great assistance to a court when dealing with section 60:11. The first one is State versus Vanka. It's from the year 2000, the second volume of the South African Criminal Law Reports, page 371, and it's a Transkei decision. The second one is State versus Botha in under 2002, the first volume, South African Criminal Law Reports, page 222, and it's a decision of the Supreme Court of Appeal. Worship, I submit that both of these cases confirm that a formal onus rests on an accused who is applying for bail to deduce evidence which will convince a court that exceptional circumstances exist. Worship, and then there are two other cases that I would like to refer the court to that states that there is no onus on the state to disprove the existence of exceptional circumstances. The first one, State versus Mpu Lampula, 2002, the second volume of the South African Criminal Law Reports, page 133 of the Eastern Cape. And then the matter State versus Scott Crossley, 2007, the second volume, South African Criminal Law Reports, page 470, and it is a decision of the Supreme Court of Appeal. Worship, when we come to the strength of a state case, the following decisions I view important. The first one, State versus Van Wyk, 2005, the first volume of the South African Criminal Law Reports, page 41. It's an SCA decision. Worship, insofar as the state case is concerned, the court held the following. The function of a court in a bail application is to prima facie determine the relative strength of the state case and not make a provisional finding of guilt or innocence of the bail applicant. The court goes on and says the following. To conclude that the case for the prosecution is weak or failing by drawing a conclusion based on credibility findings is undesirable and is a disregard of the fact that the bail application is not a dress rehearsal of the trial. The other matter, Your Worship, State versus Noble and another. It's a 2019 decision, the first volume. It's of the High Court of Namibia. It's on page 206. At paragraph 27, the court says the following. The bail application is an inquiry and not a trial. If trial-related issues are to be decided during the bail application, this may amount to prejudicing of issues or prejudging of issues that are to be decided during the trial. Submissions made by the legal representative on behalf of the first applicant is telling the court that the court must accept inside the tavern people are drinking. Alcohol is playing a very big part thereof, and one cannot really rely on what is happening inside the trial or inside the tavern. This is exactly, Your Worship, is my submission to the court. What Van Wyk and Noble warns against is for the court to decide trial-related issues in the bail application. All that this court must do, Your Worship, with respect, is to prima facie determine the relative strength. If we collectively take the evidence the state has at this stage, without the DNA evidence, my submission is one cannot argue or find that the state case is hopeless or will in all probability fail. It cannot be said. It is preempting and premature. Bishop, there's two cases that there was an attack on the strength of the state case, which ended up before high courts, which is of importance. The first one is Jacobs and others versus the state. It's a 2004 decision, volume 4 of the All SA Law Reports. It's page 538, and it was a Transvaal Provincial Division decision.
Jacobs
and others versus the state. In this matter, Your Worship, the third applicant was denied bail. By the High Court sitting as a court of appeal in respect of the bail application. The only evidence the state had against the applicants in the matter, and then specifically the third applicant, was a 204 witness who was missing at that stage. His whereabouts were not known. In that matter, the court also remarked that the 204 witness did not have clean hands. But the court denied the bail of the applicant on the basis that the court found incriminating evidence in the conduct of the third applicant. What transpired in the matter was that the third applicant deliberately tried to falsify his identity in an identification parade. And this raised a question with the court as to why the applicant did that. And the court inferred that the actions of the third applicant was to avoid being pointed out and being implicated in the crime. Is that not fitting in exactly with the conduct of the first applicant in this matter? He wants the court to believe that Pinky is either lying or making a mistake. His girlfriend is not telling the truth, the police are not telling the truth, his brother is not telling the truth. The first applicant deliberately supplied false information to distance himself from the shack in which bloodstained clothing was found. Pinky told the investigating officer, "I know him. He does not visit my house. He did not visit on when the feast was held." It's not a question of mistaken or a bona fide mistake. It is not that simple. It is a lie. Worship, in the matter of Solomons versus the state, it's a 2019 decision. It's volume 2 of the All SA Law Reports, page 833 of the Western Cape. The bail applicant alleged that the state's case against him was weak, in that it was based on the version of a Section 204 witness who was a self-confessed murderer, drug dealer and gun runner who allegedly made contradictory statements. the presiding judge was not persuaded that the state case was necessarily weak because it intended to rely on a witness who would be called in terms of Section 204.
Barrington,
As a
just go.
comprehensive Your Worship, apologies for interrupting my elder colleague. My client is indicating that he would like to see me. Can I take instructions as a comprehensive?
Maybe he wants a break or something.
Your Worship, he is indicating that nature is calling. May I request a short adjournment?
I see it's now 20 minutes past 4. So, how long are you still have a far way to go, Mr. Harrington?
Yes.
Is it okay? The court will adjourn for 5 minutes then, okay? Let us continue. Mr. Hampton,
Thank you, Worship. Your Worship, to conclude in respect of the Solomon's decision, the presiding judge was not persuaded that the state's case was necessarily weak because it intended to rely on a witness who would be called in terms of section 204. The court in paragraph 57 put it as follows: I can hardly make a credibility finding against the section 204 witness in motion proceedings. Any conclusions about evidence during the trial would be nothing more than mere speculation. Those are matters that a trial court should decide on. Worship, in the matter of State versus Mpula 2007, the second volume of the South African Criminal Law Reports, page 133 of the Eastern Cape, the magistrate had before him the fact of evidence containing a confession against the applicant. The applicant indicated that he would contest the admissibility of this confession on the grounds that he was induced by police assault. Which may to an extent be thought to take away from the strength of the state case. He did not, however, give rise to the presence of exceptional circumstances that warranted the release of the applicant on bail. Worship, what I'm asking of the court with reference to the case law that I quoted is that this court do not decide on trial issues. I submit that the only aspect that must be decided on, and I say this with respect when it comes to the strength of the state's case, is for this court to decide is there a prima facie case against the applicants. I disagree with my colleagues when they say there's only circumstantial evidence in this matter. It is not the case. We have the evidence of two independent witnesses saying the applicants incriminated themselves in the commission of this crime. Worship, there's two matters that I would like to refer the court to when it comes to the bringing in of an application based on an affidavit only, as in the case of accused number or the second applicant. The first one is the State versus Matebula decision 2010, the first volume of the South African Criminal Law Reports, page 55 of the Supreme Court of Appeal. And the other is the matter of John Martin Kiwi It's case number A66 of 2013 of the Free State High Court, an unreported decision that was delivered on the 2nd of April 2013 by the learned Judge Daffy.
Is it KEEVE?
Confirm that. In those cases, it was held that when an accused elect to discharge his onus by way of affidavit, the evidence is not open to be tested by cross-examination and therefore are less persuasive. Furthermore, an accused's denial of complicity is resting then solely on his say-so, with no witness corroboration and or objective probabilities in favor of the accused. Your Worship, the matter of State versus Jonas, 1998, the second volume of the South African Criminal Law Reports, page 673 of the Eastern Cape. It was held that in exceptional circumstances are established when an accused is able to adduce acceptable evidence that the prosecution's case against him is non-existent or subject to serious doubt. Worship, the emphasis here is on acceptable evidence to be adduced. In the decision of S versus Muhammad, 1999, the second volume of the South African Criminal Law Reports, it's page 507, and it's a decision of the Cape province. It was found that strong independent evidence tendered by an accused pointing towards his innocence can establish exceptional circumstances. In Kasu, Your Worship, we cannot say that acceptable evidence was adduced by the applicants or strong independent evidence. We only have the say-so of the second applicant, and he's not even saying it in his application before court. That he has an alibi. He says to the court, I elect to remain silent. He is not trusting the court with any facts.
But no. I will not testify to the fact that applicant number 2's wife made an affidavit to the effect of confirming that he slept that night at home.
Worship, my submission is, if we look at Matebula, he did testify. He does testify. But if we look at Matebula and we look at Kiwi, the onus is on the applicants to show and to prove. They must discharge that onus. The responsibility lies with them. If they do not discharge that onus, that is the end of the inquiry. That onus must first be discharged.
So what you're saying, I must look at the evidence in compartments.
That's not what I'm saying. What I'm saying is the law says that or discharge the onus. My submission is he did not discharge the onus. There is not strong independent evidence showing of their innocence, Your Worship, is my submission to the court.
So the decision Senekal Magistrates huna hai umata hai wotisana moja kifakie ikinitsi.
Worship, if we look at the personal circumstances of each of the accused, if we look at the financial position that accused number 1 finds himself in the sense that he owns no movable property, no immovable property, no bank account, no history with any financial institution. He would not forfeit the bail money if he does not return. His parents will. Applicant number 1 is a classic case of being a flight risk. He has no employment. What keeps him in the district of Bolu? My submission is nothing. It is a well-known fact, Your Worship, that our borders with Lesotho can be crossed on foot. Lesotho is less than 120 to 150 kilometers from Bolu. To compare a stock theft matter of 13 sheep with a murder and robbery case, where in the one instance you might get 5 to 8 years if convicted, and on the other matter where you face life and 15 years, I submit is not fair when one wants to argue that the accused, or at least that case is proof of the fact that the accused will stand his trial in this matter. Bishop, when we come to the personal circumstances of the second applicant, the issue that I would like to highlight is the previous convictions supplied by himself, and then the convictions supplied by the South African Police Services. They differ materially in respect of offence committed, as well as the year in which they occurred. At no stage was it the case for the second applicant that I'm not sure of my previous convictions. He stated it as fact. He wanted this court to believe that in 1986, 1994, and in 2000, all of them 20 years or more ago, I had brushes with the law. For stock theft, illegally buying a pig and the stock theft. Where the police are saying stock theft, house breaking, and trespassing. Why did the second applicant not take this court into confidence and say, it was in 2011 was my last? Why did he want the court to believe it's more than 20 years ago? This of a man that was not prepared to take the stand but only do it by way of affidavit. Your Worship, my submission to end off my arguments are the following. The state showed their hand and took the court into confidence and informed the court that prima facie there is a case to answer by the applicants. The applicants did nothing more than mere denying the evidence against them insofar as what happened on the 2nd of October. It was shown that the alibi of the first applicant, or the alibis that he tried to create, is subject to serious doubt at this stage. The version of the second applicant could not be tested by cross-examination. And he was dishonest when it comes to his previous convictions. Bishop, that brings us to the DNA evidence that is outstanding. I have conceded that from the preliminary DNA results that we have, the two applicants cannot be linked to the Hilux bucky.
Jwale amohetse moo mabapi le hore diteko tsa pele le moo tsa mantlha tse leng di etsahetse mane reng ya Highlands ha di ma
The court will remember the evidence was that the Hilux bakkie of the deceased was found in the direction of Bethlehem on the N5, more or less 13 kilometers from the crime scene.
Lokotanta ukubona hore Highlands ina vele inafuna zilinyane mfalifia zilile mbetile ngo pero
The two applicants were seen walking in the veld over the mountains behind Fateng Nso, coming from where the crime was committed.
ba kusona ba bili he ba bona etse mo mo ba hlala hlapore mo la thalo mo thuke mo lo ketsa etseng ka teng.
Is there then not a ring of truth in the evidence of the witness that saw them coming over the mountain?
Ile no ga hona go nete mo mo ba mo ba ba kiane e mo leng ne ba hlala hlapore le
If their DNA cannot be linked with the bakkie.
ai be lo re ya bansa mane veni
We know that there were more attackers.
ya tseba hore ya ola mahlaselo tse feta mo
Insofar as the finalization of the DNA evidence is concerned, and I want to stress it, Your Worship, that is with specific reference to the knife on the crime scene, the hat, the clothing that was seized, the rope on the neck of the deceased.
mabapi he le tse tsa DNA tse lo le thusi go tjoletse mahlo ya mo le o bua dintlha tse tshwanang le ditšheba tse tshwanang le go thipa e la tsona mo se ba se lo ka tiba ya la mo e ne la me le mo ha mo le di hapa tsa ntse lo ye mo le tse
We know it will take 30 to 40 days. Everybody is trying to expedite the analysis.
ya tseba he o se se ka nka ma tse mo shoma ba o ya shoma amane ya mo le ma mo tse mo le mo o le le tso be e ka bona kiso.
There are two cases dealing with outstanding formal investigations that must go through formal processes that I would like to refer the court to. The first is State versus Dlamini.
Here we are Dlamini he the kota he ga she ho na mo ke he lo sheba he utso he no ke o ke le so.
It's a 1997 decision, the first volume, South African Criminal Law Reports, page 54, and it was of the old Witwatersrand. Here the court took into consideration that in that matter the bail application was brought one day after the incident occurred. The court considered the fact that ballistic evidence was still outstanding and an identification parade had still to be held. And bail was not granted. In State versus Miguel and others, it's a 2016 decision, the third volume of the Namibian Criminal Law Reports, the High Court, on page 732. The learned Judge Liebenberg remarked as follows. It would of course not be in the interest of justice if bail is refused in circumstances where on the facts it is clear from the outset that there is no case against the accused. This would be the case where the facts are simple and straightforward and do not implicate the accused. In the same vein, it would not be in the interest of justice to grant bail, even more so when it involves a serious offence. If the state's inability to make out a strong case against the accused at the time of the bail application can be ascribed to the investigation being at a primary stage and the state requiring more time to build and strengthen its case. This one would find where the investigation is complex and is likely to take up more time than usual to investigate. I submit, Your Worship, the state cannot be blamed that the DNA analysis is not available at this stage. Investigations like that and analysis like that takes time. The court cannot be blind to this fact. It is of common cause that clothes with bloodstains on them were found in the possession or was found at the house or houses of the second applicant.
Not the first applicant.
I confirm, sir.
Because you said second applicant.
First applicant. His explanation for the presence of blood is questionable, false if we look at what Pinky is saying to us. A factor this court cannot ignore is that his explanation for the blood is false. Your Worship, a lot has been said about the violence that broke out here at court at the first appearance of the accused, and blame is trying to be placed on the fact that one should consider it as criminality and thuggery which led to what happened here. Whatever the reason, I submit is not relevant at this stage. What the court must take note of is of the reaction of a large portion of the public. It was extreme and it was exceptional. It cannot be argued away that there was an extreme reaction by members of the public and an exceptional reaction. It is not so remote or improbable as in any other case or other cases of this nature. It already happened, and it happened on a very large scale. Bishop, when one comes to the averment by the two accused that they are unaware of the identity of the witnesses, and with specific reference to the first applicant that he's only aware of Pinky and the girlfriend, I submit that that is not an honest reflection of the situation. Keep in mind that the first applicant told the court, I was not at Bufaku Tavern on the 2nd of October, the evening of 2 October. Two independent witnesses say they were, him and the first applicant. The evidence was that one of the witnesses that came forward with information to the police regarding what or how the accused applicants incriminated themselves were seated at the same table as the applicants. Now, surely by way of deduction, one can figure out as to who the snitch is. Furthermore, Your Worship, in respect of the Kiwi decision, hearsay evidence is admissible in a bail application. A witness was already threatened. The threat is to such an extent that you will not see Christmas at the end of the year. I submit the court cannot be blind to this factor. This witness, this tavern witness, was prepared to make an affidavit under oath. That is how serious it is. She or he has taken it. Is it so remote that we can say, or can we say in this matter, that our witnesses will not be threatened, harmed, or intimidated? Or has the state said or proved there is a fair degree of probability that this will happen? Worship, my submission is prima facie there's a case. The accused or the applicants did not discharge the onus placed upon them. I submit that they must be kept in custody. Those are my arguments. If there's anything, I would gladly address the court. If not, I will rest.
Thank you, Mr. Brendin. Polenia, and
But
any
unfortunately, I have some issues with the
legal, if any arguments in reply, legal
Yes, I have
arguments, of
some
course.
issues in reply. I would want to exercise.
I hope it's legal arguments.
Is what?
I hope it is legal, on legal points.
That's correct.
Okay. Mr. Mutaung, yourself?
At this moment, Your Worship, I don't have.
Okay. You may proceed.
Thank you, Chief. As the court correctly advised me, I would, because most of the issues that were mentioned, Pinky and others, I've already really addressed the court already, so I won't go to that really. My learned colleague mentioned number of case laws that talks to confession, identification, parade. Those cases are not relevant in this matter. I submit for, therefore, they are irrelevant. The facts of this case are completely different. There's no confession before this case. There's no issue of identity before this case. So they're irrelevant. And last aspect, as the court has warned me not to get into, to focus myself on the issue of law, I just want to reiterate, because Mike Lennon keep on raising, and I think that is his argument, that there's a prima facie case, therefore bail must be refused. I want to remind you, maybe he missed it when I said it. S versus Isaac says the court held that the presumption of innocence operates in favor of the applicant, even where there is a strong prima facie case against the applicant. That is the law, the position of the law.
Anything else?
That's all.
Said.
Your Worship, can I just raise one other aspect?
Okay.
Your Worship, in replication, my learned colleague made mention of the fact that applicant number 2 failed to adduce viva voce evidence. What is confusing about this argument, Your Worship, is the fact that in the same breath, my learned colleague is make mention of the fact that we're not in a trial here. Are we questioning, or is he questioning, the probative value of the evidence as presented to this honorable court by way of an affidavit? Your Worship, an aspect which my learned colleague finds a bit problematic with regards to the approach to this case of presenting affidavit as a form of evidence is that this court does not have the accused version in as far as alibi is concerned. How convenient, Your Worship, particularly when one takes into account the evidence that is presented by Captain Mayberg, which evidence actually confirms now an alibi in respect of a written statement from applicant number 2's wife. If the accused person elected to remain silent, that is well within his rights. Is there overwhelming evidence? And if one was to even lower the bar, is there prima facie evidence in any event which prompted applicant number 2 to respond to any of the allegations? I submit with respect, Your Worship, that there is nothing untoward regarding the applicant number 2's election to adduce evidence by way of an affidavit. And thus, it is bizarre that my learned colleague would want and call upon this honorable court to draw an adverse inference on his failure to present viva voce evidence. Such argument I submit with respect, Your Worship, that it must be rejected. As it is fatally flawed in law. As the court pleases.
Okay. You have nothing further to say, Mr. Eric?
Nothing, thank you, Worship. Exhausted.
Okay, it's already 10 minutes past 5 in the afternoon, and the court is not in a position to give judgment in this bail application today. Hence, the matter is to be postponed, and the next postponement date will be the 22nd of October 2020 for judgment. You may stand. Gentlemen, matter is postponed to the 22nd of October 2020 for judgment. In this bail application, both of you will remain in custody until then. You understand that? That conclude anything else?
That's the lot. Thank you.
Court adjourns.
Yes.
But